on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area.
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer. I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
it just happened right before your eyes. Good luck to you.
This court hearing goes off the rails almost immediately. Judge Urich is dealing with a sovereign citizen who either has no idea what he's doing or is putting on a strange act. The man is facing 2 charges of public indecency after a bizarre incident in a park, and things quickly get out of control. Do you think he's serious or just pretending? Let me know in the comments. And don't forget to like and subscribe for more crazy courtroom moments.
Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. There is a count 2 misdemeanor in that on the same date you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owns the estate yet.
Mr. Engot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today.
He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member, impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying assault from 2019 out of Parkwood Woods, which looks like it was deferred up as assaulting a public officer or obstructing.
Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
Given everything that's before the court at this time, the court will set bond in the amount of $50,000, cash or surety, no 10% allowed at this.
Judge Urich really knows how to handle situations like this. While many judges would lose patience with sovereign citizen arguments, he stays calm and carefully points out the contradictions. Setting a $50,000 bond seems like a smart decision, especially since the defendant already has multiple felonies and is still young. He seems mentally unstable, but the big question is whether it's real or just an act. What do you think? Let's continue and see what happens next.
If Mr. Stringer wishes to bring various motions before the examining judge, and that could include a motion to modify his bond. That is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on with the, what is going on? Right now?
I'm sorry, sir?
I'm being charged. How do you charge an entity that is?
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
Did you hear what he just said? He actually told the judge, "We're about to go to war." That's probably one of the worst things you could say in a courtroom. If it were up to me, contempt of court would happen immediately. Now we're moving to his second hearing, this time with a judge who is known for being much stricter. Things get intense quickly. Before we continue,
State your name.
tell me what you thought about the first
I
hearing.
don't acknowledge myself as legendary stranger. I'm a living entity.
Okay, is there another name that you go by, sir?
As a living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
I do think it, given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mont-Lewis, can you prepare an order for competency review?
What do you think about the judge ordering a competency evaluation? When a defendant tries to fire their lawyer but may not be mentally competent, it can create serious problems for the case. Even though he clearly thinks he understands everything, it seems like he's struggling to follow what's happening. That can slow down the whole process and even affect whether the trial is fair. It's like trying to play chess without knowing the rules. Let's get back to the hearing.
To consider that request until I can determine whether or not he's competent. If I would remove Mr. Sanutko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What labels me
Evaluation.
What labels me incompetent? My intelligence, because I have a high IQ?
No. That's not it, sir. There are different legal standards, but really it comes down to whether or not you can understand the nature of the proceedings at this time, that you have the ability.
I overstand the nature of the proceedings.
That you have the ability to assist your attorney in your defense.
To withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father, and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number, and he did not do that. So I would like him to withdraw from my case, sir. I have no. So he isn't competent enough for me, honestly.